I'm going to start off with the parenting plan and then move to the child support and then move to the liabilities and then spousal support will be last. So as far as the parenting plans, one factor that was of concern that Ms. Malone raised was the location of where Mr. Malone is residing. So right now we know that he's at least he's in the Mill Plain area. Ms. Malone is in the Kelso area, and that it's a 35 to 45 minute drive, probably more towards the 40 to 45, but it's within that time frame. So while that's extra time, certainly during the day, I don't think it's of such a distance or time commitment that it really is a big factor that would sway the court one way or the other. Is it a consideration? Obviously, but is it something that really guides the ship? I don't think so. So my take on this is that there's good communication between the parents related to the child. I get the sense that looks like in the early years, Ms. Malone was indicated that she is the primary stay-at-home parent, while Mr. Malone was the primary provider. And I also note that Ms. Malone has kind of worked her way up the ranks and continues to move up at Americana. So she's worked there for a period of time and has had those elevated status or jobs there. So it's also important to note that, after Ms. Malone graduates with her bachelor's, that she'll have additional time that'll be freed up and she won't have to engage in her studies as much. And that Mr. Malone will likely continue to work in his job. And so that puts both parties at working full time. And so that's kind of where we're looking at this as far as the parenting plan, kind of because how parents are working and time they have, that helps inform what time and that the parents have to dedicate to the care of your child. So obviously consistency is important for any child. That reliability of what's coming next is important for them. We know that Mr. Malone's schedule is consistent. It's not a traditional type of schedule. It's not the Monday through Friday, but has days off and days on. And we know that there's if the court were to adopt the kind of a parenting plan that's somewhat based and kind of guided by that work schedule of Mr. Malone, there's going to be more back and forth type exchanges than would be, say, like on a Monday through Friday weekend type arrangement, even though there could be potentially 2 to 3 exchanges there per week based on midweek visits and the like. So with the schedule, considering Mr. Malone's schedule, there's stretches of time where he has 4 days on, then 2 off, then 3 days on, 1 day off, 3 on, and then a weekend off, and then 4 on, and then 7 days off. So while that does provide for some back and forth, there are also long stretches in between. And I want to be sensitive too to Aaliyah and her schedule. It can be challenging for a child, I think, initially getting accustomed to a schedule that calls for those different type of exchanges in time at different parents' home. And I'm recognizing that Aaliyah's a big part of her life right now is dance. It sounds like she enjoys that and she spends a lot of her time there, probably 4, if not 5 days a week in dance class. And so if the court were to adopt the plan centered around the father's work schedule, that would add some amount of transportation time to Aaliyah's schedule. If under the current type, the parenting, there's not a temporary parenting plan in place, but the sense that I got is that the child's principally with the mother, and then she's living in Kelso and commuting to Kalama, which is a shorter distance, and then maybe coming up from Vancouver to the Kalama studio. So I just wanted to note that also, that a court gave consideration to that. The Mr. Malone's work schedule, on his days that he's working, 12 to 14 hours he's involved in work and travel related activities. It's really not reasonable for him to have visits on those days, and because it doesn't offer a lot of time for a parent and child interaction. However, on the days that he's off and that he's not working, that provides a more reasonable period of time for that residential time for a parent and child to have time together. So I think also it's important to note that once Ms. Malone is not engaged in school and has, that's a big time commitment. Once she doesn't have that then the residential schedule may need to be adjusted, because my sense is that if both parties are working full time, then a schedule that's solely based on Mr. Malone's schedule may be challenging, because I don't, as a full-time nurse with a BA, the schedule may be different, and who knows what that will look like. So I think it's also important to note with Mr. Malone's schedule that, when he's working an overnight shift and he gets off at 6 a.m., it's important for everybody's well-being for him to have sleep. And that, so I'm thinking that if his schedule is adopted, then if he gets off in the morning after an overnight shift, gets off in the morning at 6 a.m., then his parenting time would necessarily start in the afternoon, because that allows for him to be rested. And then if he starts off, if his schedule, if he's coming off of a shift in the evening, then depending on the time of him getting off, he could potentially do a pickup of the child. I'm not sure exactly what the times are, but if it's too late in the evening, then the next day could be the pickup. But if it's in the afternoon, 5 or 6, then the pickup of the child could occur. So giving consideration to that, my sense here is that while Ms. Malone has traditionally been the more primary stay-at-home parent, she also has been working during the marriage, working her way up through Americana, while Mr. Malone has been primarily the provider. Things are different now. The parties has separated and are seeking the divorce. And so I'm going to grant a parenting plan that mimics or follows the work schedule of Mr. Malone, which means that during the days where Mr. Malone has those 4 days on, that'll be mother's residential time. When he has the 2 days off, that'll be Mr. Malone's residential time. During his 3 days off, the next 3 days on, that would be Ms. Malone's time with Aaliyah. Then the 1 day off, that would be time with dad. Then the 3 days on with mom. The weekend off with dad, and then the 4 days on, that would be mom's time, and then 7 days off would be with dad's time. Then as far as the decision-making, that'll be joint decision-making for medical and educational and extracurricular activities. Dispute resolution will be through court action. The exchanges, the parties both indicated that the Woodland Safeway is a good place for an exchange, or, and depending if it's, that's kind of the baseline. If the parties think it's better to do something different, you can obviously agree and make those audibles when life gets busy. As far as kind of the holidays, the child's birthday, that'll be split between the parties. Christmas Day should be split between the parties, and then Christmas Eve should alternate years. So in even years, that will be with Ms. Malone, and odd years will be with Mr. Malone. And that's the Christmas Eve. And then summer, I'm going to allot 1 week of uninterrupted summer vacation for each parent. And I'll have Ms. Malone, you'll need to submit your requested dates no later than May 1st. And then Mr. Malone, then you can submit if you desire. I know you indicated you probably wouldn't, but that would be on May 15th. You'd need to submit, at least let the other party know what your requested week is. Mother and Father's Day will be with each respective mother or father. And then the other holidays that are listed in the parenting plan, it'll just follow the regular schedule.
Okay. So when you said, sorry to cut you off, May 15th, that would be to inform Angela if I'm taking Aaliyah like on a week vacation for the summer. Okay, I got it. Okay.
That's right. Okay. That's what I have on the parenting plan. I'm ready to move to the child support. So here, the what was particularly helpful in guiding in my decision, at least on the child support, is the year-to-date pay stub of Mr. Malone, which was at that 83,009. And on an annualized basis, that pushes it close to 92,000 on an annualized basis. So even at that 83,900 up through November 23, that's about 75,45 gross. So I'm going to set Mr. Malone's gross at that 7,500 level, and also set his net income at 5,800, which allows for the federal deduction, the FICA, the Medicare, the voluntary retirement contribution, his credit for health insurance premium that he pays for the child. And as far as Ms. Malone, at her current state, she does a lot of uncompensated work, if you will, with the Booster Club, and then the other activities that represent dollar values, but it doesn't necessarily represent income. It's more offset type of a view. So I'm going to set her net income at 2,571 and gross income at 2,571 and a net income of 2,100. I should note that the parties' hourly income rates are close in parity to each other. It sounds like once Ms. Malone passes her test, she'll get a bump and raise of about $2, which would put her slightly above, or you're both in pretty close proximity. So that would normally set the child support amount in about pretty close to 950 a month. However, we have two other considerations here. One is the whole family deviation for another child for which the paying parent is provided. That's this for the 17-year-old. And then there's also the consideration of the residential split, because roughly that residential parenting plan is roughly, it's 180 roughly overnights per year for each party, plus or minus 10 days. So there's no hard and fast rule on that calculation of how that impacts the child support amount. But taking those two into consideration, I'm going to set the child support amount at 600 per month. And they'll be due and payable in half amount on the 5th and half amount on the 20th.
Okay, now is those dates, the 5th and the 20th, is those, I don't know if it's just a Washington thing, or can I, like I mentioned before, just have them take it out on my paychecks, and it won't be on the 5th or the 20th. It'll just vary, but it will come out every 2 weeks. Is that something that I could do?
Yeah, as far as the auto debit, yes, that's fine. And Ms. Malone, do you have any input on the 5th and the 20th? If it's not on those precise dates, if it's every 2 weeks on the Friday?
I don't.
Okay, I'm fine with that then, Mr. Malone.
Okay.
As far as the debts, the one main financial that happened during the party's marriage, and the flooding concerns, and that those monies needed to be spent. And so that debt will be split half and half. So whatever the balance is, each are responsible for half that amount. The tax debt from that particular year, it sounds like, that at that time, in order to file married filing jointly, Mr. Malone was seeking the Social Security number of Ms. Malone to file a joint return. And when parties are splitting, that may be very difficult, and the communication may be strained, and there may be reasons why that's not provided. During that same time period, Ms. Malone, she filed married but separate, and that was a more financially advantageous move in that she didn't have to pay, whereas the filing single, as Mr. Malone did, that the tax code, to my understanding, is much more, I don't know, it seems to place a higher burden on single folks when they file in that status. So he had to pay at least the current amount is 5,035, I believe, or 5,037. So during that same time frame, he paid that, and Ms. Malone had a refund of approximately $3,300. So during that time, so Ms. Malone was obviously benefited by filing, by using her status that she used, and Mr. Malone was uh, kind of penalized by filing under the status that he used. Um, there may have been alternatives that Mr. Malone could have sought by like maybe seeking an extension. Maybe if the communication issues were difficult regarding getting the Social Security number, that could have allowed maybe some cooling off and allowing time to obtain that and file under a different status. Nonetheless, the decisions made in the IRS isn't showing, at least according to the testimony, a lot of flexibility to alter that or do an amended return. So with that, if you take a look at that, if I were just to split the refund that Ms. Malone got down the middle, that's 1650 each, and then the 5,000 splitting that down the middle would be 2,500. So I think that on the whole, both parties should share in the refund and both parties should share in the tax debt, but in different ratios. So this is kind of how I did it, that basically you both get credit for the 3,300 in the refund, and Ms. Malone would be liable for a tax liability of 1,500 and Mr. Malone for the tax liability of 3,535. So that's a net benefit to Ms. Malone of $150 when you take the tax refund of $1,650, subtract the tax liability of $1,500. That brings it to almost a neutral amount, but in the plus amount in the black at $150. And then the father's refund credit, roughly, these are kind of talking in abstract terms, of $1,650 plus his tax liability of $3,535. That puts it at a liability of $1,885. So all that said, the tax debt at this point, the 5,035 is divided in the following manner. Mr. Malone is obligated to pay 3,535 of that debt, and Ms. Malone is obligated to pay 1,500 of that debt.
Okay.
The Rising Heights Dance Studio bill, that's kind of a late breaking item in that there's roughly $3,000 or $2,957. So this is a time the parties were together up until April of this year. Since that time, the parties have been separated, and there's been not as much communication really regarding finances. One thing that I think is clear from the testimony is that Aaliyah likes dance, and I think that and Ms. Malone is very much invested in supporting her daughter in that process through her physical presence and involvement with teaching and the like, and volunteering. So right now, so there's, the idea is that if the parties, obviously Aaliyah is benefited by participating in that. I didn't hear any testimony to the contrary. And so my sense is that if a child is being benefited by something, both parties should share some part in satisfying the debt that supports that benefit. So whereas here, Mr. Malone was somewhat shut out of that information from at least I'm making a reasonable calculation. They shut out from that information from, say, April on towards where we are today. I'm going to apply a 60-40% split. So Ms. Malone would be responsible for 60% of that debt of the 2,957, which is 1,774. And Mr. Malone would be responsible for 1,182 of that debt. And that should be paid directly to the dance studio.
Okay.
Can you repeat that amount, please?
Yes, Ms. Malone, 1,774. So 60% of that 2,957. And then Mr. Malone is 1,182, which is 40% of the 2,957. Next, on spousal support, the court looks at the financial resources of Ms. Malone and her ability to meet her needs independently. Right now, she has an ability to earn $32.50 an hour. What limits her from working more full-time on that is the attending school. She's attending full-time, and also that she's teaching dance, which is reduces the amount of, we'll call it, overhead or expenditures for the tuition. Also, I take note that the representation is that Americana has some flexibility and that Ms. Malone can indicate, hey, okay, this is my schedule for the week and this is where I can work. Go ahead and sign me up for those dates. And the indication that I heard is that they sign her up for those when she can work. So there's an indication that there's flexibility that if there's a parenting plan that the court has ordered, then there's going to be less of a burden on Ms. Malone for parenting time, which would free her up to do school and or work, and that will allow her additional means to generate financial resources. I'll note also that Ms. Malone is scheduled to graduate with her bachelor's degree in June of 2027, if all goes well. So that's what I'm using as kind of the anticipated date of graduation. The standard of living during the parties, I would describe it. It sounds like a modest lifestyle, not terribly extravagant, not on the lower end either. The parties have good running vehicles that are in good working shape. There is no real estate that I heard of that was purchased that the parties were renting, and it sounds like probably maybe a advantageous situation for Ms. Malone's mother and father. So I'm not exactly sure how to characterize it. Nonetheless. The standard of living, the way that it was portrayed is that maybe Mr. Malone is more simple in his taste, and maybe Ms. Malone has maybe a finer taste in things. So, and then there was the evidence that there was a trip to Disney World, and there were some trips. There were more, it sounds like, in last year to California due to family members passing. But it sounds like there was those California trips. There was you'd go back on occasion to visit family and friends. So that's kind of the information I have as far as standard of living. There was enough money to buy scooters and toys and the like for Aaliyah. The parties were married for 11 plus years. The representation was the parties were married in 2014. And I recognize that there were some pleadings that showed that you were together before that for a period of time. So that kind of sets it at a midterm marriage. And that, yeah. And then as far as any physical or emotional limitations by either party, neither party has any obstacles or limitations related to that. The financial obligations of both parties, both parties are very aware of the difficulties of providing for a family in today's financial stressors. So right now, Ms. Malone is paying a portion of her mother's mortgage in the amount of the $1,500, and she's getting support for the remainder. The mother of Ms. Malone is covering the remainder for the mortgage. The utilities are paid by the mother of Ms. Malone. Ms. Malone is paying for a car, paying for insurance, gas. She's paying for the dance instruction. And also there's the competition and registration fees, costumes. I'm taking into account that both parties are going to be obligated to pay the one main financial, also the tax liability. And so I look at that. And then I also look at, obviously food and clothing, those basic necessities. Mr. Malone, it sounds like there's some flexibility with his living arrangement in that he pays a rent. And it's not a fixed amount, but it's somewhere between 500 to 700. Same thing with the utilities, it fluctuates, and there's some flexibility there. There's a tax, as we indicated before. He indicated he has a car, he has insurance and the gas fees, the one main also, and the tax debt. And then he's also paying child support in this case and another case. And that there is, yeah, so those are kind of just in broad sweeps of what I'm looking at. So while the obligations are tight for each of the parties, I'm going to award $200 per month in spousal support to Ms. Malone. I think that there's a need there, and there is a slight amount of ability of Mr. Malone to provide that support. So that'll continue from January 1st through June 30th of 2027.
June 2027, you said?
June 30, 2027.
Okay.
So that's the court's order. So I'll entertain any questions if anybody has any questions.
I have a question in regards to the parenting plan.
Yeah.
The residential time, how am I supposed to, I don't have his schedule, so.
Yeah, that's something that needs to be provided well in advance because Ms. Malone, I think you said it's like a 30-day advance. So you give your notice to Americana of when you can work. Mr. Malone,
Mhm.
how often that schedule? When does your schedule come out? Do they give you an entire year schedule?
Yeah, so the schedule I have here and then I provided the courts. I have given Angela this copy before. It's for 2026, the entire year.
Okay.
Um, so if she needs another copy, I'll be more than happy to give her one.
Okay.
Yeah, I don't have it.
Yeah, if you could supply that today or tomorrow, and then supply the 2027, if you can supply that, does it come out by October for the following year? So I'm looking at for 2027. So the schedule for 2020.
Oh, for 2020, yeah, that will it my it varies. We've had turnover the last 2 years with HR and management. Sometimes it comes out in October. This year it came out like the beginning of December. So it's really hard to say. There's no like formality, like set ways.
Okay.
Um,
Let's just make sure that the schedule is supplied no later than December 1st, 2026 to Ms. Malone. And if there's some untoward event that hasn't been supplied, then you apply it as soon as possible.
I can take a picture of it and send it. I don't know if that's
Yeah,
allowed.
yeah, that however you want to communicate it and however Ms. Malone can receive it and read it. So that's
Okay.
for 2026, but I'm just thinking about 2027, that schedule, you need to supply that no later than December 1st of 2026 to Ms. Malone.
Okay.
Any additional questions, Ms. Malone?
No.
Okay. Mr. Malone, any additional questions?
Um, I think so. Okay. I have everything down 600 a month plus 200, so that's 800. Now, excuse me. Do I do I like pay that today? Do I pay that next week or when I get paid next Friday? So does that when we start it?
The spousal, yeah, the child support obligation and spousal support obligation start January 1st. So generally then with child support, it's due on the 5th and the 20th, and the spousal support, I don't know if you have a preferred date of when that's due. Generally, it's due on the 1st, but I'm open to suggestions and hearing from either party and both parties.
Okay, I'm just used to doing, like I said, everything just comes out of my check. I don't think about it. I don't do anything with it. I don't know if I can set that up with my HR. Now it might take 2 weeks or two pay cycles. I don't know. But if I can just have them take out both of, when I get paid every 2 weeks. I don't know if there's a phone number, a website that people normally call or go to do all this stuff. Like I said, I've never had to deal with it, so I'm not really sure how to go about it.
Yeah, I'm not exactly sure how those automatic debits work. You know, if child support enforcement is involved, then that can be set up directly so that payments are debited from your pay, and then it goes directly to child support. They log it in, and then they forward it on to the receiving parent. That's one option. The other option is if your employer has the means to do it through the ACH, the Automated Clearinghouse, then they can just direct it directly to Ms. Malone's account. I guess the important part is that it starts in January. And so if the automatic debit is not set up, then there'd have to be alternate means to make sure those
Right.
funds are received.
Yeah. So okay. Like I said, I get paid next Friday. I don't know if that's accept. I don't have any money right now to pay anything. So if I could start next Friday, which would be the 9th, um, then I can make the child support and spousal support payment, correct? I can do them both at the same time?
Right, right.
Okay.
I think as a general rule, the spousal support is due on the 5th. Child support's due on the 5th and the 20th. And that's kind of what I'll default to.
Okay. Now, if it does go a day or two based on my if I am getting automated payments, I won't get penalized for it or in trouble or anything like that?
Well, I think the understanding here is that there's, the 5th and the 20th are the set dates, but it's more based on the Fridays, the alternating Fridays that the pay comes out. So if it's within a few days of that date, Ms. Malone indicated that she's not too terribly concerned about that. But if it goes a week beyond that, then obviously that the court's going to be concerned about that.
Yeah, no, I understand that. Okay.
I have another question. What happens if like the schedule doesn't work?
Yeah, it's a valid question. So when there's a final parenting plan in place, there needs to be, to change it, there needs to be a motion to modify the parenting plan and a motion to find adequate cause to change the parenting plan. So the idea is that there's a parenting plan in place, it should stay in place. We shouldn't alter it unless there's a significant change. And so that's why there's an adequate cause finding needs to happen first. That, okay, there's a big enough change here in the circumstance of either the child or either parent or both to warrant a change. So that's the first obstacle to overcome. So you get, if a party is granted the finding of adequate cause, then the motion to change the parenting plan moves forward. So that's the process. So there are means to address that and to alter the parenting plan. Does that answer your question? Okay.
Mm-hmm.
Okay. All right. If any additional questions, otherwise, our plan would then to be meet back here on the 23rd at 8:45 via Zoom, and have the proposed orders in by the Wednesday prior, which I think is the 21st.
Yeah.
Okay.
Okay. All right. With that, we'll sign off and then we'll see everybody on January 23rd at 8:45.
Okay, one question. I'm sorry. I'm very sorry. I'm just concerned about the child support alimony or however you call it. Is there a phone number? Or do I just like Google Washington Child Support Services to make payment?
Division of Child Support Enforcement, I think is the term that you can use to search. So DCS, Division of Child Support Enforcement.
DCS. Okay, and they'll have like my information or the information, I guess, or
They probably won't, because my understanding with child support enforcement, that if the receiving party asks them to get involved, then they'll get involved and help set that automated transfer to occur.
okay.
If they don't get involved, then if your company, if you can set up a link, an automatic debit from your work account to Ms. Malone's bank account that she specifies, then that could be set up kind of privately that way. But those are the only two options that I'm aware of.
Okay. I just want to make sure that I get that right because I've never, like I said, never missed a payment, never been late, and I, want to make sure that I get this all situated.
Yeah, I
Okay.
don't think they can do it. I don't think they can do it unless you have like a parenting plan like in already filed. Um, so I think it has to be filed in like in actual order.
Yeah, I think that's true. And because what you're saying is that there needs to be a child support, and within the child support, there's a provision that says the Division of Child Support shall participate in gathering the
Be
funds.
like a mediator. Yeah.
Yeah.
Okay.
So, that's something that if you want to look into that between now and when we return on the 23rd, you can address that. For a lot of people, that's a lot easier and cleaner because it's set up and it's automatic. But we can talk about that when we're here on the 23rd based on what is learned between now and then.
Okay. All right. Well, thank you very much. I appreciate it.
Okay. Anything else, any other final questions or clarifications on the ruling?
No, I'm okay.
No.
Okay. All right. With that, we'll go ahead and adjourn for the day and we'll see everybody on the 23rd. Thanks.
Perfect. Thank you.
Thank you.